Imagine facing a prison sentence with no defined end date. Not for heinous acts but simply due to potential future re-offending. This is the harsh reality for many individuals sentenced under imprisonment for public protection or IPP. This contentious sentence has troubled the UK's criminal justice system for nearly 2 decades. In this episode, we will explore IPPs in detail, presenting the facts, historical context and the current discussion surrounding this issue. You will have the opportunity to evaluate whether this sentence adheres to the principles of proportionality and fairness that every justice system should honour.
Welcome to Spoken Injustice, where we put the criminal justice system in the dock. As you know, the primary goal of Spoken Injustice is to humanize the criminal justice system. 2 fundamental principles that should form the bedrock of any humane and respectable criminal justice system are proportionality and fairness. While convicting an innocent person is often seen as the ultimate failure, there are other less obvious ways the system can go gravely wrong. Cases where guilt or innocence isn't the issue, yet punishment or process is deeply disproportionate. Today we are examining one such example: imprisonment for public protection, or IPP. This sentence has long been criticized as a serious injustice. In keeping with the Spoken Injustice approach, we will present you with the facts so that you can draw your own conclusions. We'll begin by outlining the factual background, covering how, when, where and why it all began, before turning our attention to the current situation and the key arguments for discussion. But before we get started, join us in our mission to humanize the criminal justice system. Subscribe and share this video with someone who cares about justice and fairness. So how did it all start? On the 1st of July 2000, Sarah Payne, an 8-year-old girl, and her parents set off for a visit to her grandparents in Kingston Gorse, West Sussex. During the visit, she vanished. On the 16th of July 2000, her body was found in a West Sussex field, less than 12 miles from where she disappeared. Roy Whiting, a local convicted sex offender, was questioned the day after Sarah's disappearance and then questioned again and arrested on the 31st of July 2000. He was eventually charged on the 1st of February 2001 and convicted on the 12th of December 2001. I pause here for a moment to remember Sarah Payne and her family. While her mother found solace in campaigning, her father, who tragically passed away in 2014, never recovered from the devastating loss. The brutal nature of the crime and the fact that Whiting had a prior conviction for adopting and sexually assaulting another young girl in 1995 caused widespread public outrage. Sarah Payne's murder led to the campaign for Sarah's Law, advocating for public access to information about known sex offenders in their area, which eventually gave way to the Child Sex Offender Disclosure Scheme, the CSODS. which lets you formally ask the police whether someone who has contact with a child or children has a record for child sexual offences or poses a risk to the child or children for some other reason. While Sarah's law was more focused on community notification, her case also highlighted broader concerns about the management of dangerous offenders. These contributed to the climate that led to the introduction of IPP sentences in the Criminal Justice Act 2003. Indeed, to understand that climate, we need to take a look at the white paper that preceded the Criminal Justice Act 2003 called Justice for All. The people of this country want a criminal justice system that works in the interests of justice. They rightly expect that the victim of crime should be at the heart of the system. This white paper aims to rebalance the system in favor of victims, witnesses and communities, and to deliver justice for all by building greater trust and credibility. This white paper is designed to send the strongest possible message to those who commit crimes that the system will be effective in detecting, convicting, and properly punishing them. Against this backdrop, let's investigate what IPPs are and why they came into existence. Indeterminate Sentences of Imprisonment for Public Protection, known as IPPs, along with Detention for Public Protection, DPPs for those under 18, were introduced in the UK in 2005 under the Criminal Justice Act 2003. The idea was to deal with offenders who were considered dangerous but whose crimes didn't quite reach the threshold for a life sentence. The purpose was public protection. Instead of giving these offenders a fixed sentence, the court could impose a minimum tariff, and then it will be up to the parole board to decide when or if they could be released. The government at the time believed this would prevent risky individuals from being released automatically once their sentence was finished. So what were the criteria for applying IPP? Before 2008, the criteria for imposing an IPP were quite broad. Judges could impose one if the offender was convicted of a qualifying offence listed in the law and the court decided there was a significant risk that the offender would commit further serious offences in the future. There was also a presumption of dangerousness built into the law. That meant if someone had a previous conviction for a listed offence, the judge had to assume they were dangerous unless the defence could prove otherwise. As a result, many people received IPPs for offences that were not at the most serious end of the scale, sometimes with tariffs of just 2 years or less. In an article published on ITVX on the 7th of August 2025, Sangeeta Lal explains, "I have spoken to judges about how and why IPP sentences were so widely used for petty crimes like stealing a bike or a phone. And I have been told that it's because it was easier for a judge to use it than it was for them to explain why they weren't going to." After 2008, following widespread criticisms, the rules were tightened. The Criminal Justice and Immigration Act 2008 raised the threshold so that judges could only impose an IPP if the new offence itself was serious enough to carry sentence of at least 2 years, and the dangerousness test was satisfied, meaning there was a clear evidenced risk of serious future harm. These reforms reduced the overuse of IPPs for relatively minor cases, though the problems with the existing sentences remained until their abolition in 2012. So why were they abolished in 2012? IPPs were abolished in 2012 by the Legal Aid, Sentencing and Punishment of Offenders Act because they had become widely recognized as unfair and unworkable. Indeed, they were branded as indefensible. Thousands of people were serving sentences far beyond the minimum tariff, not because of new crimes, but because they couldn't prove they were safe to release. The system was criticized by judges, campaigners, and even the European Court of Human Rights for being disproportionate and for creating a sentence without end for relatively minor offences. There were also big backlog in rehabilitation courses, which made it almost impossible for prisoners to demonstrate reduced risk. In short, IPPs were scrapped because they were seen as unjust, damaging to prisoners' mental health, and a stain on the justice system. So what were they replaced with? After IPPs were abolished in 2012, they were replaced mainly by extended determinate sentences, EDS. Under this system, the judge still sets a fixed sentence with a minimum custodial term, but instead of being indeterminate, the offender is told exactly how long their sentence will last. The key difference is that the parole board only becomes involved for the most serious cases. For less serious offences, prisoners are released automatically at the halfway or 2/3 point of their sentence. For the more dangerous offenders, the parole board decides whether they can be released once they have served the minimum custodial part. This system was designed to keep public protection at the centre while avoiding the open-ended, indefinite punishment that made IPPs so controversial. So you might wonder why we are still dealing with them if they were abolished. The answer lies in a key detail. When IPPs were abolished in 2012, the government chose not to apply the change retrospectively. Consequently, numerous cases predating 2012 remained impacted, which is why this issue remains relevant today, almost 20 years after its abolition. The main reason given for not applying the policy retrospectively was public protection. Ministers argued that releasing all existing IPP prisoners or automatically converting their sentences could put the public at risk. There was also practical and political concerns. Resentencing thousands of people individually would have placed a huge burden on the courts, and there was fear that some offenders who still posed risks might be released too soon. As a result, those already serving IPPs remained trapped released under the old rules, even if their tariff had expired. This decision has been one of the most controversial aspects of the policy because it left a large group of prisoners stuck in indefinite detention long after new offenders could no longer receive such a sentence. So what are the key concerns about IPPs highlighted by campaigners and identified by the Justice Committee during its 2022 inquiry? The main concerns were, first, indefinite punishment. Thousands of people were serving well beyond their minimum tariff, creating what campaigners called a life sentence by the back door. Secondly, mental health and self-harm. High level of anxiety, depression and suicide among IPP prisoners linked to the hopelessness of not knowing where or if they would ever be released. According to UNGRIP, 287 individuals sentenced to IPPs have died in prison, including 90 who took their own lives. Thirdly, barriers to release. Many could not access the rehabilitation courses required to demonstrate reduced risks, meaning they were effectively trapped in prison. And disproportionate use. IPPs were often imposed for offences that were not at the most serious level, with the tariff as low as 2 years. Finally, license and recall. After release, individuals continue to serve under an indefinite license, living with the ongoing threat of a recall. In many instances, they have been recalled not for committing a new crime, but for violating the terms of their license. The Justice Committee's third report found the Ministry of Justice Action Plan for reducing the size of the IPP prisons population lacked a clear strategic priority and ownership, as well as operational detail and performance measures, and found that the parole process and the probation services involvement in it were ineffective and posing a significant barrier to progress for IPP offenders, and that the government needed to devote far greater energy to tackling the recall merry-go-round. They recommended a set of reforms, including a resentencing exercise, a time-limited scheme to resentence all remaining IPP prisoners under current sentencing framework, improved support, better access to courses, psychological help, and resettlement support to help prisoners progress towards release. License reform, ending the indefinite license by reducing the qualifying period for termination from 10 years to much shorter fixed periods. Stronger oversight, regular reporting to Parliament on progress in reducing the IPP prison population, specialised support in the community, help for those on licence to avoid unnecessary recalls. The government accepted some changes which were implemented in the Victims and Prisoners Act 2024. Key changes to IPP introduced by the Act were reduced qualifying period for licence termination. Previously, IPP licence holders could only apply for termination 10 years after their first release. New provisions under the Act shortened this period. From the 1st of November 2024, the qualifying period was amended to 3 years for IPP offenders and 2 years for DPP offenders for the purpose of automatic license termination, but remained 10 years for other purposes. On 1st of February 2025, the qualifying period for all other purposes, including when the Secretary of State must refer a DPP and IPP license to the Parole Board for consideration of license termination, was changed to 2 and 3 years respectively. The Act also introduced powers for the Secretary of State to dismiss IPP recalls, i.e. intervene in recall decisions, and re-release recalled IPP prisoners using an executive mechanism akin to a risk-assessed recall review. In addition, the government is now required to lay an annual report before Parliament detailing steps taken to advance the rehabilitation, release or license termination of IPP and DPP offenders. However, the government crucially rejected the committee's central recommendation of a full resentencing exercise. So while IPPs can no longer be given, their legacy is still with us. The debate continues today about whether resentencing or further reforms are needed to finally bring closure to people still trapped by this abolished sentence. In the meantime, the CCRC announced on the 1st of August 2025 that it is re-examining historic applications to review DPPs and IPPs imposed on children and young adults. The CCRC has previously referred 12 cases to the appellate courts where IPPs were a factor. 8 have either had their sentence quashed, reduced or substituted. These projects has been developed following 2 Court of Appeal decisions to quash IPP sentences in 2024, Leighton Williams and Darren Hilling, who were both young adults when they were sentenced. In both outcomes, the court determined that the sentencing judge had failed to attach the necessary importance to the age and maturity of the offender before giving the sentence. The CCRC has launched a review of historic applications to ensure that any which may benefit from these decisions could be looked at again, and a specialised progress group led by a commissioner are working on current applications to determine whether any could be referred to the appellate court as a result of these developments. Still, the CCRC has made clear that it cannot refer cases simply because IPPs have since been abolished or because they may appear harsh or unfair in hindsight. And that is the heart of the problem. These are not just technicalities or statistics, they are human lives. Nearly 2 decades later, thousands remain under this shadow of a sentence that no longer exists, punished not for new crimes, but for the system's own failings. This is not justice. So what do you think? Do we need full resentencing to end this injustice once and for all? Drop your thoughts in the comments below and share this video to help amplify the call for change. Join us again as we sit and rise in this unique trial.